Kia ora, Joseph. Look, thank you very much for coming along to this Justice Subcommittee to make a submission on the principle of the Treaty of Waitangi Bill. I'm going to kind of dispense with the formalities because time is tight, and we're giving you 10 minutes to submit, including any questions that members may ask. So I'm going to hand straight over to you and invite you to make your submission. Kia ora.
Talofa lava, ma lo le soi fo mawa, ma le langi e mama, bozu se, a me la even ke mana, a me la te jehu. Tēnā koutou, toi tū te mana o te whenua, toi tū te mana motu ake, toi tū te tiriti o Waitangi. My name is Joseph Hulwe. I am an Indigenous Canuck from New Caledonia. I am Samoan. I am a father, a husband, and in my spare time, a lawyer. Today, I have the honor of making oral submissions on behalf of the Pacific Lawyers Association, or the PLA. We vehemently oppose the principles of the Treaty of Waitangi Bill. These submissions do not intend to represent all the views of the multitude of separate and vastly different cultures from the Moana or the Blue Pacific, but rather our mandate emanates from the diversity of Indigenous Pacific peoples and our affiliates reflected in our membership. They include members of the judiciary, the legal fraternity, students, business leaders, volunteers, and members of the Pacific Island community in Aotearoa. We reiterate our support to Te Hungaroa Māori o Aotearoa, or the Māori Lawyers Association, and we endorse the findings of the Waitangi Tribunal's Ngā Matapono reports. But above all else, we stand together with tangata whenua Māori, who are our whanaunga, as Indigenous peoples of Moana, Nui a Kiwa, or the Pacific Ocean. Our peoples developed cultures, rich cultural praxis, navigated the largest ocean in the world, thousands of years before European contact and the untimely imposition of Western political thought. We reiterate this significant and important historical context because it also formed part of the context in which Māori operated when they signed Te Tiriti and agreed through grace and aroha to work in partnership with the Crown and its many subjects. It is in spite of putatively damaging and pernicious tools like this bill that Māori continue to entrench and protect their innate and inalienable rights, both as the first persons of this land and Te Tiriti partners. We support our brothers and sisters, especially when their dignity and rights are under attack. The PLA views this bill as the proverbial snake in the grass, or to paraphrase the indelible Natalie Coates, the taniwha pretending to wear Te Tiriti bedazzled korowai. The bill, which was ostensibly doomed to fail, aimed to bring about a much-needed national debate about Te Tiriti. The framing of this bill and its contents obfuscates the bill's true intention, and that is to impose a finality to erase and be done with the country's foundational compact insofar as it removes the recognition of tino rangatiratanga and halts Māori progress towards meaningful redress and reclamation. The bill seeks to unilaterally create a legal fiction from the ashes of ignorance and misconception. It is a bill that contravenes our Constitution. The courts over a course of more than 40 years have developed the principles of the treaty as a way to give effect to Te Tiriti in the absence of applying the text directly. It looks to mimic the spirit and meaning of Te Tiriti and the treaty in a way that holds at the heart of its development the existing relationship that exists between Māori and the Crown. This relationship requires the parties to work together in good faith, and even goes as far as to impute a responsibility on the Crown to protect Māori interests. Interests Te Tiriti and the treaty sought to protect. This bill is not even an attempt at developing the laws on the principles as they currently are. It cannot even be said to be a shadow cast from the dilution that is the current treaty principles. That is to say, the bill is far more removed from Te Tiriti than even the current treaty principles. Rather, it is a tool that will be used to disestablish the several attempts by both Māori and the Crown to acknowledge the historical context in the hopes of moving forward as a country. Clause 9 of the bill is perhaps most dangerous, saying that the bill will not amend the text of Te Tiriti. It is clear from its intent, echoed by its sponsor, and its contents, that it may not change the words, but it will make sure that they lose their meaning. Finally, the bill is incompatible with Aotearoa's international obligations under the United Nations Declaration on the Rights of Indigenous Peoples, or UNDRIP. Aotearoa was a reluctant signatory to this foundational text, and our courts acknowledged its significance in domestic law, commenting in the Supreme Court case of Ellison the King that tikanga and/or tikanga-derived principles are part of the fabric of Aotearoa New Zealand's law and public institutions, highlighting Aotearoa's commitment to UNDRIP. That commitment to UNDRIP includes a commitment to Māori people's right to self-determination under Article 3 of that compact. The bill has been made without any consultation or consideration of Māori self-determination and looks to disavow rather than acknowledge the importance of tino rangatiratanga. We urge the legislature to rid themselves of this misconceived and disquieting bill and to consider a world where our constitution and the rights of Indigenous peoples from the moana can work harmoniously for the greater good of this amazing country. Whakataite lava, Olusat, Oleti.
Kia ora, Malo. Thank you for that, Joseph. We do have some questions, so we'll go straight to those tākata first.
Tēnā koe te rangatira, kei ngā ngāngo te moana nui a kiwa tēnā koutou. E hoa, I know that you're just a lawyer in your spare time, and more importantly, we're fathers. So I'm interested to hear from you, and from a point of view of the Pacifica community, we're pretty clear that there is some insidious and quite likely intergenerational damage being done to our tamariki and our mokopuna. I want to ask you if you think that that damage would spill over to our Pacifica tamariki and mokopuna.
Well, I think what those submissions try to address clearly is that part of the Pacific community includes tangata whenua Māori. So the issues that affect Māori are issues that affect those from the moana. And that's because we have an inextricable historical link that spans generations before us and will certainly remain generations after we leave. So yes, please. Simply put, what you say or described are things that we will, as those from Moana Nui Pacifica, we will experience too, for sure.
Kia ora, thank you for that. We've got two more questions, so I'll try to get to them both. Steve? You got your mute thing going?
Mute, there you go. Thank you for your excellent submission. You mentioned specifically at point 25 about United Nations Declaration of Indigenous Peoples that it described as a mutually reinforcing standard of both self-determination and tino rangatiratanga, which in effect creates the basis upon which tangata whenua can seek to determine their own affairs within the context of partnership with the Crown. Why is it, and it might seem an overly simplistic question, why is self-determination and the right to determine your own affairs so important to peoples?
No, thank you for that question, Steve. I think what you'll find, and it's the experience of a lot of Indigenous cultures, particularly those in the Pacific, where we experience interaction with our former colonial powers more meaningfully and in a more protracted sense, right? And self-determination means more because anytime we come to any discussion or table where what's being discussed implicates not just the people who are sitting at that table, but our future generations, our mokopuna. We see that enabling ourselves to have a basis upon which we can say and describe the ways in which our lives should persist from here on out is part and parcel of self-determination, and that's why it's so important to us. And that's why we are always ensuring that at any discussion about the future or the current status of our people in relation to other people within the country, that we make it really sacrosanct and because we need to be able to do that. Sorry, so I know I'm taking up time.
Kia ora, I'm just out of time, and I did want to give the last member who had a question, Joseph Mooney, a quick opportunity. Joseph.
Oh, thank you, Mr. Chair. Thank you, Joseph. Look, just your comment you made, I didn't quite catch it, and I'm just wondering if you can clarify your comments around the Western legal thought in the Pacific, whether you saw that as a negative, whether you agree with the concept of the rule of law or not.
I think, well, what I'm trying to say, and I think I reflect that more towards the end of the oral submission, is that what's better is to conceive a world where the two, because of the situation that we find ourselves in, can work together harmoniously. But what that means is that we don't denigrate one so that it assimilates to the other. We can have the rule of law, and we can have systems of governance that we've inherited. But it doesn't mean to say that they cannot be incompatible with the rights and dignity of Indigenous peoples. And that's really what I'm trying to make up very clear.
Thanks for that, Joseph. I'm going to cut you off there because we ran out of time, but I think you answered my question.
Yes, it's very relatable. I relate with Duncan. We've run out of time. Yeah, that's that is very relatable when you're doing a submission. So I find this really interesting. Hearing from, he's from New Caledonia, but it's really interesting when we look at the wider context of the Pacific right now, especially with the Cook Islands having free association and trying to do trade agreements with China, and the Luxon government or our current government getting all up in arms about that. It's really interesting to see the dynamics here between Pacifica people, Polynesian people, and the Crown. Yeah. What are your thoughts?
Well, I put a lot of my wider thoughts, my idle thoughts, into what is the rule of law. I'm quite a philosopher, so I haven't come to a useful conclusion yet, not at all. I'm still sort of debating it in my mind, or maybe I should get out there and debate it with more experts in their field, as somebody said. Mm-hmm. You're not a lawyer, and you're an expert in your profession. I'm thinking, wait, what am I an expert in at the moment? Like, even with horticulture and plant science, I'd still say I'm just an advanced understanding of computers and systems, advanced understanding of mental health at the first-hand level, or 2 degrees. So, show me another way, or just stop.
Yeah, I mean, that's the thing. It is good to hear from people who work in this field, because we're not lawyers. I'm not a lawyer. You're not a lawyer. We're all hearing a lot of this stuff for the first time. I'm not an expert in anything either. My expertise is just reading. That's all I do, is just reading. I mean, what's your expertise? It's just being cute, isn't it, buddy?
Yeah, so reading and listening and maintaining that attention, rather than saying, let's say they go as first peoples of Aotearoa, and then someone goes, oh, but there was somebody came before you. Like, well, that's a whole other historical conversation that's not relevant to because the people that were here, the last first people who were here, don't talk about the people that were before them again, to be like, oh, that invalidates you being there first. There's just too much debate that takes away from
to those people. I would say maybe there were people that came here before Māori. I don't know. I haven't seen any archaeological evidence of that. But even if there was, that wouldn't undermine Te Tiriti. Te Tiriti is still an agreement between, it's still a partnership, it's still a treaty between Rangatira Māori and the Crown. And I think that argument there is saying, oh, these other people came first. Well, the treaty is not with them. The treaty is with Māori, and using that as a distraction from the implications that the Crown, presented by the Crown, by them breaching Te Tiriti and the socio-economic impacts and fallout from that.
And is it right to say Crown? Is it, because we'd say Crown entity as the...
I think it's appropriate to say Crown, considering that Queen Elizabeth was the Queen at the time of the treaty, and we're still part of the Commonwealth. We can say Crown.
Yeah, I do think we might need absolute law, and I get that it becomes complicated trying to. I prefer more of the experts in their field, judiciaries, to be able to use their discretion and be trusted.
Yeah, I mean,
because to have absolute law be equitable is very difficult, and
I think that highlights a really. That highlights a really good point, actually, Ray. Sorry to interrupt, but the lawyer did say that the framing of the bill hides the true intention seeking to undermine the foundation of the country by the government defining the obligations rather than allowing the tribunal to interpret the text directly. And I think they're acting essentially as a barricade for judges to just do their damn job. Essentially, it's like saying, no, you've got to interpret it this way, and you're kind of shoehorned into interpreting it this way, rather than being able to look at the original text.
So a lot of what the Regulatory Standards Bill talks about is barricades and handbrakes and all sorts of reasons to stop progress. And while I agree some things could be more efficient, not just at the simple expense of you're not allowed to have your say, let's fast track everything. Yeah. I did submit on that.
That's good. It's important to allow people to have democratic participation and voice their opinion on stuff. And that is one good thing. That's one thing I'm going to credit this bill with doing, is that it's encouraged participation in a democratic way. People have submitted on this, people have brought forward their arguments, and I do think that is a good thing. So we've come to the end of the show, or the end of this hour, folks. So we've got Sam and Matthew, Tukaki, a very special guest, and they're going to be doing the next hour of the show. So thank you so much for tuning in. It has been a pleasure to host for you guys. And thank you to Ray and Stacey as well.
Thanks for watching. Make sure you're subscribed to our Facebook, YouTube, Twitch, Instagram, TikTok.